So I'm Georgia Mason, Director of the Campbell Centre for the Study of Animal Welfare. I'd like to first acknowledge that the land we're on resides on the traditional, unceded or treaty lands of First Nations, Inuit and Métis people, depending on where we are in Canada. And of course, here in Guelph, we're on the traditional territories of the Mississaugas of the Credit. And this is my last chance before February 19th to remind you that our closest former residential school, which was run on Six Nations land, is now called the Woodland Cultural Centre. And on February 19th at 6 p.m. it's running and screening an online movie about the school and what it was like to be a resident there. So I'd highly recommend that. Okay, on to today's event. So we have the fourth of our mini-series talks on protecting animals through the mechanism of the law. A few weeks ago, we heard from Camille Lebchuk on problems with animal protection in Canada and possible solutions. And I'm really thrilled that Sophie Gaillard has agreed to join us today to speak on a similar theme, but taking a particular angle, whether declaring animals sentient can lead to better protection. So Sophie graduated from McGill's Faculty of Law, and she was one of the first animal protection lawyers in Canada. She's currently Director of Animal Advocacy and Legal and Government Affairs at the Montreal SPCA. And in her position there, she works to improve animal law and animal protection under existing laws. And her efforts have included campaigns leading to the banning of declawing of cats in Quebec, which is great, and also a provision in the Civil Code of Quebec recognizing animals as sentient beings. So that seemed like a huge advance, but did it have the effects they were hoping for? That's what Sophie's going to cover today. So Sophie, it's lovely to see you again. I'm really looking forward to your talk.
Thank you so much, Georgia, and thank you, everyone. I'm really excited to be here. Just want to warn you, I have a little bit of a lingering cough, so you might hear me cough once in a while, but I have my water and I have my cough drop, so I should be able to make it through the talk. Okay. So the topic, as Georgia mentioned, that I want to explore with you today is the issue of recognizing animal sentience in law. And I'll be focusing on Quebec as a case study because it's the only jurisdiction in Canada that has formally recognized animals as sentient beings. And so it really presents us with a good model for exploring what it actually means to enshrine animal sentience into law. So here's a quick overview of what I'll be discussing today. I'm going to start with a quick background on the status of animals as property, and more specifically, their legal status as movable property in Quebec prior to 2015, which is when they were formally recognized as sentient beings in our civil code. And we'll also look at some examples of how this property status impacts animal welfare. Then I'll briefly talk about the Montreal SPCA's campaign that led to the recognition of animal sentience in 2015, which was our Animals Are Not Things campaign. After that, we'll look more closely at Article 898.1 of the Civil Code, which is the famous article that recognizes animal sentience, and we'll also compare it to similar provisions in other jurisdictions. Then I'll go over some of the case law to give you a sense of how courts have interpreted the provision, and that'll lead us into a critical discussion of what it actually means to recognize animal sentience in law. And I'll end with some thoughts on what further reforms could be made to make sure that sentience recognition provides animals with meaningful legal protection. So animals as property. So the legal universe is divided into two fundamental categories. We have persons on the one hand and property on the other. And animals have been property for millennia. In fact, the domestication of animals is very closely related to the development of the very notion of property. And this is how that person property dichotomy played out in Quebec prior to 2015. This is what our civil code pre-2015 states. So every human being has a legal personhood or juridical personality, as we call it in Quebec, which is the ability to hold legal rights. But they aren't the only ones. It's not only human beings. There's also legal persons, that is corporations. They also have legal personhood and the ability to hold rights. And property is the category that covers everything else. And that's further divided into what we call in Quebec immovables or movables. Movables are things that can be moved either by themselves or by an extrinsic force. And this definition is a little bit cryptic, but things that can be moved by themselves actually refers to animals since they can move by themselves. So this was the breakdown in Quebec prior to 2015. We have persons on the one hand, which includes human beings, even the worst ones, but also corporations. And then on the other side of the wall, we have all non-human animals and inanimate objects. And they're both lumped together in the same category of property. There's no distinction at all in the law prior to 2015 between a toaster, a house, a cow, or a dog. And I'm specifically referring to Quebec here, but this is actually the current situation in other provinces. And in fact, throughout much of the world, we have this division of property, and persons and animals fall within the property category. But it's important to remember too that historically this hasn't always been immutable. There have been instances throughout history where certain entities that were previously considered property have managed to break through this barrier and become persons. So, you know, a famous example is human beings like slaves were considered property at some point. But at some point in history, they did manage to break through this divide and become legal persons. And before going further into a discussion of animals' property status, I just want to make a quick side note to point out that this is essentially a provincial and not a federal issue. The Canadian Constitution sets out the distribution of legislative powers, which is basically telling us what's under federal jurisdiction versus provincial jurisdiction, and private property, which is, as you see now, the current legal status of animals falls under exclusive jurisdiction of the provinces. So the federal government does have some jurisdiction over animal welfare via particular heads of power that are federal in nature. For example, the power to enact criminal laws, and that's why we have animal cruelty provisions in our criminal code. But if we want to actually change the legal status of animals, that pretty clearly falls under provincial jurisdiction. So it's really a provincial issue. So now we'll move on to some of the impacts that this property status has for animals. And I don't know if any of you have heard of the story of the IKEA monkey, but it actually illustrates one of the main impacts of considering animals as property in the eyes of the law, and that is that their interests cannot be taken into account when there are civil disputes that arise, namely in order to determine the ownership of the animal. So I'm going to just go over this case because it's pretty crazy and fascinating in terms of a case. So we'll dive into it. So there was this woman named Yasmin Nakuda who was really into exotic animals. She lived in Ontario and she had owned a number of exotic animals. And then one day she decided that she really wanted a Japanese snow macaque because, quote, she had seen a video of one waiting on tables in a restaurant and thought it was interesting. And so she contacted one of her exotic animal dealer friends and ended up being able to buy in Ontario a Japanese snow macaque for $5,000, and she named this macaque Darwin. And then on a day in December in 2012, Nakuda went to a Toronto area IKEA with Darwin the monkey in her car. And she left him in the car while she went into the store, but he ended up actually escaping both his crate in the car and the car itself. And he wandered into IKEA, as you can see on the slide here, wearing diapers, and a shearling coat. And he ended up being picked up by Toronto Animal Services, who brought him to a sanctuary. And Nakuda filed suit against the sanctuary to recover ownership of Darwin. Trying to decide on this issue of who should be allowed to own him. This is a quote from the decision. The court does not have jurisdiction to determine what is in the best interest of the monkey. For example, is it best for him to live with Miss Nakuda or in the sanctuary? The monkey is not a child. Callous as it may seem, the monkey is a chattel, that is, a piece of property. The court may apply only property principles when considering the issues in this case. So a pretty cold way of approaching this dispute. Luckily for Darwin, the court ended up deciding that ownership should go to the sanctuary based only on property law principles. But luckily it ended up being in favor of him staying at the sanctuary. And now Darwin, the IKEA monkey, has his very own Facebook page if you want to follow him on social media. And though this Darwin IKEA monkey story is pretty sad, I'm sure you'll agree, it did, I have to admit, generate some pretty hilarious headlines, tweets, and memes. So I'll just share some of those with you. All right, so the invisibility of animals' interests because they are property is also frequently seen in pet custody disputes. Courts will generally recognize the strong bonds that people have with their companion animals, but because animals are legally property, they refuse to depart from the strict application of the rules that govern the separation of marital property in pet custody disputes. And when trying to determine the custody of children, the overarching principle that courts have to consider is what's in the best interest of the child. In animal custody cases, the key consideration is who bought the animal. There's no consideration for the animal's interest or welfare unless there is specific legislation governing this, like there is currently in British Columbia. So one example of how this ends up these cases end up being decided in court is this Henderson case that involved a dispute over the custody of a dog called Tuxedo after the breakup of his owners. Both parties were jointly asking for court for a joint custody order, but the court refused to grant the custody order, reiterating that dogs are property and basically scolding the parties for wasting the court's time with what they essentially considered to be a ridiculous application. So here's the actual quote from the decision. Am I to make an order that one party have interim possession of, for example, the family butter knives, but due to a deep attachment to both butter and those knives, order that the other party have limited access to those knives for 1.5 hours per week to butter his or her toast? A somewhat ridiculous example, to be sure, but one that is raised in response to what I see as a somewhat ridiculous application. So I think it's pretty clear that the court finds it completely ridiculous to consider the animal's welfare in this kind of case. So to be property as a matter of law means essentially that your interests are legally irrelevant. They just don't count. And another important consequence of being property is that by definition, property is not endowed with legal personhood, and being a legal person is a prerequisite to being able to hold legal rights. So if you're property, you cannot by definition hold any legal rights. And though animals do benefit from certain protections under our criminal law, under our animal welfare legislation, this isn't the same thing as having actual rights. And I'm going to go on a quick tangent to explain the difference. Um, so here are two examples of legislative provisions that confer a certain degree of legal protection on animals. The Criminal Code cruelty provision, which makes it a crime to cause unnecessary suffering to animals, and this section of the Quebec Animal Welfare and Safety Act, which sets out owners' duties of care to their animals. Now, offenses like this are typically conceptualized as offenses against the state, which means they are exclusively enforced by state agencies. So typically it's the state itself that enforces or delegates powers to another entity like an SPCA, for example, to enforce the legislation. But private citizens like you or I, or private organizations, can't really sue to enforce those laws. Sorry, I'm skipping ahead here. And this has a real impact in terms of on the ground, because whether these protections actually get enforced depends, one, on the willingness, and two, on the resources of the entity that's charged with enforcement. These entities, whether they're states or state and other entities acting as agents of the state like SPCA, have a broad degree of discretion in choosing whether they're going to intervene in a particular case. And when you think of certain entities charged with enforcement like police, well, animal crimes against animals may not fall on their top priority, right? Crimes against people, they're not necessarily sensitized to the importance of enforcing animal cruelty laws, and this can impact enforcement on the ground, of course. Also, these entities often have limited resources. So prime example being the SPCAs across the country that do enforcement. So sometimes even if they're very willing to enforce the law, they are stretched too thin to be able to deal with every case. And I spent many years at the SPCA overseeing our enforcement work. And I can tell you that this represents a large number of cases. A large number of cases where clearly there has been an offense that's been committed, but because it's relatively minor compared to other much more serious offenses that you're dealing with, resources, while you choose to only go after the most serious offenses. Another issue with this being conceptualized as an offense against the state is that animals aren't victims of the crimes, but rather they're pieces of evidence. And sometimes they have to be held as evidence, which would lead me into a whole entire separate talk on the issues around having to hold animals as evidence, but it's a really problematic issue. And also, animals are not directly represented in these cases. So you have the Crown or the prosecutor who's representing the state, and then you have the accused who has his or her defense attorney, but the animals' interests themselves aren't directly represented. And it's important to keep in mind, too, that animals aren't unique in benefiting from certain legal protection, the law, even though they're property. So for example, national parks or public monuments are also protected from certain harms or certain forms of destruction. But in contrast, full-blown rights, the rights like you and I have, are directly enforceable by rights holders. So if our rights are being violated, we can sue whoever is violating our rights. And this is true even of children or incapable adults who can sue via a legal representative that is charged with exclusively representing that person's interests. The state doesn't have to be involved at all. And the interest of the right holder is directly represented. So all this to say, bottom line, that though animals have certain protections under animal welfare legislation, they remain property and thus they don't have full-blown rights. So that's the end of that side note. Moving on to the Animals Are Not Things campaign. In 2014, we at the Montreal SPCA launched this campaign demanding that animals be recognized as sentient beings in Quebec law. The campaign was endorsed by a number of public figures in Quebec, so musicians, TV hosts, journalists, scientists, TV personalities, etc. And we got a lot of media coverage right off the bat because of these high-profile signatories, but also because what we were asking for seemed to really resonate with the public. The essential ask of this campaign was that the law stop considering animals as mere things. And this seemed to be something that almost anyone could get behind. So we ended up with 52,000 signatures, which is a good performance in terms of our campaigns. And also because of some luck in terms of timing, the campaign really quickly caught the government's attention as well. So shortly after the launch of the campaign, there was an undercover investigation of a Quebec veal farm that was released by the organization Mercy for Animals, and that really made headlines. It was really shocking footage. And the newly appointed Minister of Agriculture reacted very forcefully to this story. He used very bold language reacting to it in the media. He said he wanted a small revolution in terms of animal protection in Quebec, and that he was making this one of his top priority. Then the Animal Legal Defense Fund published, which is an American organization, published its annual rankings of Canadian provinces based on the strength of their animal protection legislation. And as had been the case for the prior few years, Quebec was ranked at the very bottom. So this put additional pressure on the Ministry of Agriculture, who again reacted to this rankings report, saying that they wanted to make sure that Quebec would rectify the situation when it comes to animal protection in the province. And so the minister announced his intention to introduce a bill, invited us to submit our recommendations, and the bill was introduced almost a year later. It had two components. So one was an amendment granting animals the status of sentient beings in the Civil Code, and two, the creation of a brand new provincial law exclusively dedicated to animal protection, the Animal Welfare and Safety Act. And public consultations were held on the bill. We obviously, of course, participated in those. There was general support for the bill. One of the only groups that opposed the bill was the agriculture industry. They were worried that recognizing animals as sentient beings would be this slippery slope towards granting them full-fledged legal personhood and banning agriculture altogether. So here's a quote from the brief that the UPA, the Union des Producteurs Agricoles, the Producers Union, the Provincial Producers Association, essentially. This is a quote from the brief that they submitted in the context of the consultations. So they say, for some groups, this is a first step towards the future recognition of personal rights for animals, enabling them to be respected or considered as persons before the courts in the same way as children or unfit adults. This is worrying for the future of livestock farming. So we'll discuss in a moment whether their fears were founded, but spoiler alert, almost 10 years later, actually 10 years later now, eating meat is still perfectly legal in Quebec. And though animal use industries do tend to oppose sentience legislation for this reason, because they fear that it will open this door to one day granting animals true legal rights, they do tend to be rather discreet about it, at least in Quebec, because they do this sort of out of the public eye, probably because from a PR perspective, it's pretty hard to come out against recognizing animals as sentient without looking pretty backwards. So this was more of an approach that they took behind the scenes rather than publicly. And finally, in December 2015, the bill was unanimously adopted by the National Assembly. So here is what we ended up with in the Civil Code, this new provision recognizing animal sentience. This is the first paragraph. Animals are not things, they are sentient beings and have biological needs. So far, so good, right? But here's the second paragraph. In addition to the provisions of special acts which protect animals, the provisions of this code and of any other act concerning property nonetheless apply to animals. So even though we're declaring that animals are not things, we're nevertheless going to continue to treat them as if they are things. So this second paragraph really guts a lot of the significance that the first paragraph could have. And it also indicates that we haven't truly broken free from this person versus things dichotomy in Quebec. Also, because the term sentient beings is not defined in the civil code and doesn't appear anywhere else other than this provision, we don't really know what it means exactly in terms of what implications it has or what kinds of protections could potentially attach to it. It's very unclear. But what does seem pretty clear is that the provision is essentially declarative or symbolic. It redefines animals as different in nature from inanimate objects because they are sentient, but doesn't really challenge their status as property or give them any additional protections. This provision that we adopted in Quebec is very closely modeled on equivalent provisions that you find in other jurisdictions, some of which you see here. So as you can see in France, in Switzerland, in Germany, it's always the same basic formula. We recognize that animals are different in nature from property because they're sentient, but nonetheless, we subject them to the exact same legal regime as property. So though the purported goal of these provisions is to formally distinguish animals from mere things, to make sure that the law no longer sees them as things, the actual consequences of this are pretty minor in practice. And in fact, when you look at the jurisprudence in these jurisdictions where they have enacted these provisions for decades now, for example, in Germany, this was enacted in 1990, it's pretty obvious that it hasn't in and of itself led to significant changes for animals. So now we're going to look a little bit more closely at how Quebec courts have interpreted Article 898.1 since it was enacted. The majority of decisions that cite the article actually just use it to confirm that despite the fact that the law now recognizes animals as sentient, the legal regime applicable to property nonetheless continues to apply to animals. So for example, by finding that the legal warranty against hidden defects in products applies to animals, or that animal custody disputes are to be decided using the principles that apply to property. Therefore, as we saw, ownership will typically be given to the spouse whose name is on the adoption paper or on the sale contract, even if this runs contrary to the animal's best interests. And courts have continued to rule on pet custody in this way, even though we now have Article 898.1. In fact, they've explicitly rejected the argument that 898.1 would have any bearing on how animal custody disputes are resolved. So for example, in this case, the court remarked that it is evident that dogs are not children. The court has no jurisdiction to determine their custody, nor to grant visiting rights in the dog's best interests. The court agrees that dogs are considered in law to be personal property, and that disputes between people claiming the right to possess a dog are determined on the basis of ownership. So this was despite the argument having been presented to this judge that 898.1 should impact how custody decisions are made. And fixing this specific issue of pet custody is actually something we're currently working on at the SPCA. We have a campaign on this issue, and I just wanted to share one of the visuals we have for this campaign because it's kind of funny. But keeping with the theme of jurisprudence on 898.1, in 2019, the Quebec Court of Appeal, so the highest court in our province, decided a case in which it had to interpret this article in the context of a legal challenge to a euthanasia order against a dog who had been involved in a serious bite incident. And the Court of Appeal's general take on the issue was that even though animals are now recognized as sentient beings, this doesn't mean they can't be killed. It only means that the method used to kill them must take into consideration their sentience and therefore must be as gentle and painless as possible. So you see here on the slide some of the quotes from this case saying that animals nevertheless remain subject to the legal regime of property, that 898.1 doesn't itself prohibit killing animals, but that killing has to be done in a manner that respects sentience. However, this isn't of much added value because we already have provisions in our animal welfare legislation, which requires that when animals are killed, it's done in a manner that minimizes pain and anxiety. So the Court of Appeals decision doesn't really add much to the existing state of affairs. One of the most recent cases centering around sentience recognition in Quebec is the Longueuil deer cull case, which you may have heard of. So in 2022, the city of Longueuil decided to, and Longueuil is just a city south of Montreal, decided to cull up to 100 white-tailed deer that were living in one of its urban parks. A lawsuit was instigated by an animal rescue group and a private citizen against the city of Longueuil and the provincial Ministry of Wildlife to try to stop the cull. And we at the SPCA decided to intervene in the case, which means that we became a party to the lawsuit, and thus we were entitled to present evidence and make arguments in court. And we decided to do this for two reasons. One, because we wanted to broaden the debate and trigger a serious public conversation in Quebec on how we should manage human-wildlife conflicts. In essence, what we wanted to argue is that resorting by default to lethal methods when managing wildlife is no longer socially acceptable, given that there are alternatives that exist and that governments must develop expertise in humane, non-lethal, sustainable management practices. So that was one goal of intervening. But the other goal has to do with sentience recognition, because we wanted to invoke the fact that animals are now recognized as sentient beings as part of our strategic litigation efforts to basically try to force courts to interpret this provision and tell us what it means exactly. As we've seen, the meaning and implications of the provision are really unclear. So this was a case that presented us with an opportunity to try to encourage judges to interpret it as broadly as possible in the hopes of actually ending up with an interpretation that imparts some kind of tangible benefit to animals. So more specifically, our argument was that animal status as sentient beings requires that governments take into consideration their sentience and therefore their welfare, but also their interest in remaining alive. Which can seem a little bit of a stretch maybe, but to support this line of argument, we produced a philosophical expertise by a very well-known Quebec animal ethics scholar. Her name is Valérie Giroux. And in her expertise, she explained that recognizing sentience from an ethical, philosophical perspective necessarily implies recognizing that animals have an interest in continuing to live. Here's an excerpt from her report. So she explains that there have been various theories regarding how to explain the nature of the harm that's caused by death. And one of the main theories is that the harm of death is that it deprives someone of the good things in life. So according to this theory, the reason why dying is detrimental to the individual who dies is that that individual then loses all the good things that he could have enjoyed had he remained alive. And sentient beings are capable of not only unpleasant states, but also pleasurable states. And so all the positive experiences that constitute their well-being are snatched away from them when their lives are ended. And it is undeniable at a minimum that being alive is a necessary condition for being able to experience the good things in life. So we were pretty excited to see what a court would make of this. And what we were arguing, just to be clear, it wasn't that animals have this absolute right to life and can never be killed, but simply to say that if we've recognized that they're sentient, it means that we've also recognized that they have an interest in living and that non-lethal methods should be favored over lethal methods whenever possible. So we weren't saying it was something absolute, but rather that it should be a factor when making decisions about animals, whether wildlife or other types of animals. It should be a factor to try to prioritize solutions that can preserve animals' lives. So the expertise was admitted into court as evidence, but it was rejected by the court. So meaning her expert report came into the case, was considered by the judge, but the judge ended up disagreeing with the arguments that we presented in relation to the expertise, saying that while Article 898.1 recognizes that animals are sentient beings, it doesn't recognize their right or interest to live, nor does it impose a preference for methods of control that ensure their survival over lethal methods. So point, didn't work out for us with that argument. So to summarize, the only real tangible effects we've seen of sentience recognition in Quebec is in two areas. One is the nature of animal boarding contracts, but this is a little bit technical and doesn't really have much impact. It has to do with how we classify animal boarding contracts, whether they're services contract or deposit contracts. Very technical, doesn't have any impact. I'm not going to go into it. The other area where we actually have seen an effect is the amount of damages that an owner can claim when his or her companion animal has been harmed or killed due to someone acting negligently. So for example, in this case, Paquin and Langlois, a dog's owner who had to, the owner of a dog who had to be euthanized due to a genetic defect sued the breeder for damages. And the court said that since the coming into force of Article 898.1, the court considers that in general, the value of moral damages suffered by someone following the loss of their animal should be higher than it was before, when animals were only movable property. So this is one of the only areas where we've actually seen an impact of 898.1 in the last decade. So taking a step back to look at the cases that we've just discussed, it's pretty clear that courts so far have approached sentience recognition very cautiously, choosing to interpret the article pretty narrowly. However, the provision has inspired courts to speak about animals and the importance of protecting them in an entirely new manner than before. So in the case I was talking to you about, the Court of Appeal case involving the challenge to the dog euthanasia order, the Court of Appeal said that by affirming animals are sentient beings, the legislature dictates the conduct that must be followed by all those who interact with such beings. This provision has the value of a behavioral standard. And in the Longueuil-Deer case, the Superior Court said the following: decision reflects the Quebec legislature's recognition that animals have an intrinsic value that is not exclusively dependent on their utility for the human beings with whom they share the planet. So this reflects a really progressive way of speaking about animals in Quebec courts, something that we hadn't really seen before this article was enacted. So what does it mean to recognize animal sentience in law? Well, recognizing sentience in law in and of itself, if there's no other reforms that accompany it, unfortunately doesn't lead to many immediate tangible benefits, for example. As we saw, it doesn't allow animals to truly break free from the thing category in the eyes of the law. And also, sentience is already implicitly recognized in our animal protection legislation. So there isn't much added value to that aspect of the provision in terms of concrete impacts. After all, if it's a criminal offense to cause unnecessary suffering to an animal in Canada, it's necessarily because we at least implicitly recognize that animals can feel pain. So the fact that sentience recognition on its own has such limited tangible impacts has been the focus of a lot of criticism by scholars, as you can imagine, including Marcelo Ferrari, who says the following, speaking of sentience recognition in New Zealand, Oregon, and Quebec. Overall, in each jurisdiction, it is clear that the legislative recognition of sentience itself has not led to a sea change. Animal status has not changed in any significant way. Ultimately, the recognition of sentience has done little to improve the welfare and protection of animals. And this point of view reflects the general consensus among scholars and jurists that sentience recognition is largely symbolic and doesn't have any immediate impacts, or very limited immediate impacts. And the risk of this from an animal advocacy perspective is that sentience recognition could be used by politicians to demonstrate that they're really taking action on animal protection by adopting this noble provision that will revolutionize how animals are seen in the eyes of the law, without doing anything to truly improve animals' lives, and that could have possible political costs. So some argue that sentience recognition, excuse me, could actually block or stall more effective legislative reform. But on the other hand, recognition of sentience, sorry, I'm just going to take some water. Apologies. I made it through so well up until now. Cough drop time. Okay. So on the other hand, sentience recognition can have a lot of value. First of all, even if it's only symbolic, it's probably worthwhile for the legal system to formally acknowledge that animals are distinct from other types of property. But also, it acts as a very powerful signal that animals' interests matter and that animal protection is an important social and political goal. It really reflects an acknowledgement on the part of society that animals have moral worth. And it does lend considerable legitimacy to efforts to improve animal protection and legislation. And thus, it can be used to help pass other reforms that do bring about tangible change for animals. Because once you've recognized that animals are sentient, it becomes harder and harder to justify treating them in a way that completely disregards their interests. And from personal experience, I can tell you that pretty much every single campaign we do at the Montreal SPCA to advocate for changes in the law, we invoke animal sentience and 898.1 because it allows us to say that the status quo, allowing X or Y bad practice, is incoherent with the fact that we have already acknowledged as a society that animals are sentient. And we've seen that judges are extremely cautious when interpreting sentience recognition, probably because they're afraid that if they have this broad interpretation, it could lead to unforeseen consequences and have certain impacts beyond the decision at hand. And judges generally want to avoid making these kinds of broad interpretations when they don't know in advance what the ultimate impacts will be. But nonetheless, sentience recognition does create this first stepping stone that we could use eventually with bolder judges to have additional meaning read into the provision and have it actually mean something a little bit more than it currently does. So potentially it could lead the way to more progressive jurisprudence that in turn could actually have a concrete benefit for animal welfare. So this type of progress is slow, it's haphazard, but it would still be progress. This idea is very well summarized by Ferrari again, who says that recognition of sentience may represent an irreparable chink in the armor of humans' legal dominance over non-human animals. The idea of sentience has caused small pieces of grit to lodge in the common law, and although it may take decades, something more powerful might eventuate. So some words that make me hopeful. So as I mentioned, one of the main ways, one of the risks associated with sentience, um, enacting sentience legislation is that it'll get enacted, but it won't actually do anything for animals on the ground. So one of the ways to mitigate that risk is to make sure that whenever sentience recognition gets enacted, it comes with accompanying reforms that do concretely improve the lives of animals. And this was the case in Quebec in 2015. As I told you, the amendment to the Civil Code was coupled with the enactment of another piece of legislation that did actually increase the level of protection for animals in the province. And so I know that Camille Labchuk's talk before mine already gave you a good sense of what changes need to be made in Canada in order to adequately protect animals. So I won't be repeating any of that. But I did want to end the talk with a brief discussion of some ideas for reforms that could actually directly build on sentience recognition, but would go further in terms of giving animals additional protections. So first, it could be interesting to put in place a sentience committee like there is in the UK that is responsible for scrutinizing government policy to determine whether it has adequately taken into account animal welfare. In the UK, this committee is composed of independent experts from diverse fields, of course, scientists, veterinarians, etc., animal protection people as well. It's a brand new committee. It was appointed only last year, but it has already successfully influenced some government policy in the UK. One example being the Renters Reform Bill, where the Sentience Committee's input highlighted the animal welfare implications of pets in housing and making sure that housing is accessible to people and their pets. Another option that's a bit more out there would be, but that would allow us to truly break free from this person versus thing duality, would be to create this brand new hybrid category for animals that would be somewhere in between the persons and things. So we would give in this scenario sentient beings a kind of partial legal personhood that would allow them to hold certain rights. So these rights could be very basic, limited, and specific, mainly geared towards protecting aspects of welfare. So for example, the right to express species-specific behavior, for example, but not necessarily a right to life. We could also imagine a general requirement that animals' interests be considered in any actions or decisions that affect them. And in this model, animals would still be subject to the property regime, so they could still be, bought and sold and even killed for human purposes, though perhaps some practices would no longer be allowed. And of course, to make sure that these rights are meaningful, we need to think about a legal representation mechanism that would allow animals to exercise these rights. But as I mentioned earlier, this is something that's totally imaginable because we already have certain human beings who can't themselves assert their rights, like children or incapable adults, and we have legal representation mechanisms in place for those humans. So we could have a similar kind of mechanism for animals. And finally, a last thing to think about is the remedies that we would want to make available in cases where animals' rights have been infringed. Because when we're dealing with civil cases, the typical remedy is monetary damages. And we could imagine that monetary damages could be awarded in animal cases, for example, to the legal representative, to be held in trust, to be used to pay for the animal care expenses. But likely, we would also want other types of remedies available. For example, like an injunction that would force an animal owner to do or not do something, for example, that would prohibit using the animal for a specific purpose, or force the owner to provide better living conditions for the animal. And another important remedy, of course, in animal cases would be the ability to confiscate the animal, so remove ownership of the animal from the faulty party. So this is a little bit out there. I mean, it's something I occasionally dream of at night. It's not something that would be imaginable in the short term, but it's interesting to think about in terms of in the long term, how sentience recognition could morph into something more meaningful for animals. But it would definitely be a marked departure from the status quo in terms of how the legal system thinks of animals. And that concludes my talk.